You need to hear the application by the EFF and the amaBhungane Center for Investigative Journalism to unseal President Cyril Ramaphosa's CR17 election campaign records. In 2019, Ramaphosa's lawyers obtained a High Court order sealing the campaign records, saying it contained confidential third-party information. Judge Aubrey Ledwaba, who granted the order, said any party interested in accessing the documents would need to make a formal application to the court, prompting the EFF to do so. So legal journalist Karyn Maughan joins us now to discuss what's happening. Good to see you, Karyn. Thanks so much again for talking to us.
Thanks for having me.
So before we go into the details, why this campaign specifically of previous presidents had their records examined? I mean, what is it about this? It's all a bit of smoke and daggers, beginning obviously with the public protector.
Well, the most important thing is that the public protector, as we well know, did an investigation into a 500,000 rand donation that the late Karyn Maughan, CEO of corruption-accused company Bosasa, made to the president's CR17 election campaign. He told Parliament initially that was a money for a consultancy agreement for his son. A few days later, retracted that statement, said he was now aware that it was in fact a donation. Musi Mayamani, then the head of the DA, lodged a complaint under the Executive Ethics Code with the public protector, saying that he felt that the president had misled Parliament and should be investigated. And he also raised questions about the way in which these payments to the campaign had been made. She then asked the Financial Intelligence Center for information in relation to this 500,000 rand donation, and it gave her a full report about the various accounts linked to CR17, and also annexed or attached all their bank statements. I think it was several months worth, might have even been up to 2 years worth of bank statements, but it was a large amount of bank statements, and she used that to then come up with the finding that she believed that the way the payments were being conducted raised a prima facie suspicion of money laundering. Of course, the FIC, subsequently now in this case, we don't know what that report said in full, but we do understand that it made no such finding of money laundering or any suggestion thereof. But the crisp issue at the moment is the president successfully challenged the public protector's report. We know that that's now before the Constitutional Court. The public protector is seeking to appeal that ruling. And it was found that her investigation was unlawful, that she didn't have the right to investigate CR17, and that all her suspicions with regard to money laundering were legally and factually unjustified. But the EFF are now saying that basically they believe that the citizens' right to know who funded the president's election campaign should trump the right to privacy that his campaign fundraising committee is saying should protect the identities of those donors. And they're saying that there's this broad issue of our society dealing with corruption, dealing with all kinds of problematic aspects of governance, and they're using the My Vote Counts judgment in the Constitutional Court to argue that public disclosure of this kind of funding information is one way of ensuring that governance is transparent and open to the public. Of course, the campaign funders are resisting that, as is the Financial Intelligence Center.
All right, so that's a great background into where we land ourselves right now. So would the argument by the EFF be that the president wrote to Deputy Judge President Aubrey Ledwaba and that there wasn't an open court process, which of course might have led to a different outcome?
I think that's part of it. I mean, there wasn't an order granted. It was a directive that was given by DJP Aubrey Ledwaba, because basically what happened was the bank statements had people's bank account numbers, they had names, they had confidential information in them. and what the president's lawyers expressed to the DJP was concern about that information being made publicly available. Of course, the presidential campaign fundraising committee's lawyer, Ramaphosa, yesterday arguing that under the law, all of our bank statements are confidential and secret and cannot simply be publicly disclosed. Yeah. But part of the difficulty was, I think, that it was in chambers. It wasn't in an open court. And Camille Premield, who was arguing for the EFF yesterday, saying, in response to questions from Judge Kasim Sadiwala, that in fact, we don't really know what informed that meeting. There wasn't necessarily a transcript, and that we didn't have a sense, which was what the judge was asking for, of the reasons of the DJP in the particular circumstances to issue that directive. Of course, the president's lawyers hit back and say, well, he said you could challenge it in court, in the court process, during the process itself. You chose not to do that. And they're also pointing out that, in fact, the EFF and their lawyers had full access to the CR17 record. So they do know what's in it. They have seen what's in it. Obviously the bank statement information, all the documents that came before the public protector, but they have had access to it. So it's not like within the litigation itself, the fight over the CR17 report, that people didn't know what had come before the public protector when she made her report, which was subsequently invalidated. I think, Leanne, what complicates the situation so much is that we've seen the former President Jacob Zuma and subsequently backed up in many respects by the EFF leader, Julius Malema, come out and say that Ledwaba's decision was basically corrupt or nefarious because he was trying to protect the identities of judges who were on the CR17 payroll. Now, there's absolutely no evidence in that of that in the documents that served before the lawyers, and I know because I've spoken to them. And also, one would imagine that if any such evidence had emerged in the course of the public protector's investigation, there is no way she would not have investigated it, because that would be highly, highly problematic. She's already found suspicions of money laundering. Of course, they were subsequently invalidated. But if that kind of finding was made, it would be very, very serious.
Yeah, that certainly would do. So, I mean, that leads to the question, why do you think the president is against the unsealing of these documents? I mean, despite arguments forwarded by the EFF's lawyer advocate Ishmael Mnisi, they talk to the prioritization of public interest, transparency, the public's right to know. This, of course, should trump the donor's right of privacy. I mean, obviously, making these documents public, you're not about to give the banking details out. It's just the names that are in question. Because we all know, we're coming from a time where, well, we're not maybe still in a time of state capture, because that unfortunately is the reality. There is that connection that's always made between donations and corruption, and that shroud of secrecy on donors could be an opening to special favors and corruption. I mean, and that's possibly what we're seeing at play right now. What is your take about this, especially at this level and the capacity of a state president?
I think you have absolutely hit the nail on the head, because there's two tracks here. There's the legal track and there's the political and optics track, right? So legally, at this point in time, there's nothing in the law that discloses someone who's engaged in an internal party election that forces them to disclose who their funders are. The Executive Ethics Code doesn't do it. The My Vote Count judgment requires parties to disclose who their funders are, but there's relative silence around this issue of if you're writing within a political organization and you campaigning, whether you have to disclose. Now the EFF is saying, listen, you were running for the presidency of this country. Obviously, there's a public interest dimension, just as I think there would be in any kind of internal political campaign, because you would want to know who had backed the specific candidate. But at this point, Leanne, there's nothing in the law that says a person who's running inside an election internally must disclose. But outside of that, we are a corruption-ravaged country. We have come through the state capture inquiry, which has been a plethora of information about kickback culture, specifically within the ANC. South Africans have innate suspicion towards the state because of what we've experienced, because of the kind of issues that we are dealing with continually as a country as a consequence of corruption. You know, the constant load shedding, all the kind of lived ways in which corruption has influenced our lives on a very real and profound basis, and specifically and more devastatingly, the lives of the poor. So when you as the state president withhold or seem to withhold information about who funded your campaign, albeit on very good legal grounds, optically that does not look good.
Yeah.
And Camille Premild also saying, look, we just want to know who the donors are in order to ensure transparency. But as I said before, I think the bitterness and the toxicity that has surrounded this thing about CR17, we've heard judges are on the payroll, journalists are on the payroll, it's a routine accusation that's leveled against anyone's political enemy, is that you're on the CR17 payroll. It's now assumed a very, very adverse character. And if there isn't, transparency about that, which, if the court makes a decision, that perhaps, legally there isn't a basis to disclose this information, I think it's just going to create more speculation, rumor, and innuendo. And unfortunately, that's not healthy for democracy either. Yeah. So, I absolutely agree with you that South Africans are very likely, if that information isn't disclosed, not to not respond in necessarily a positive way. That being said, I think that this matter has really opened the question of whether there needs to be a push for a legal basis, amendments to legislation, whether it be the Executive Ethics Code, whether it be a second, challenge with, in relation to my vote counts, to say, okay, let's put it on the table then, that this needs to be a prerequisite, that donations to campaigns of this nature do need to be universally public, and so that the public has that information available.
Yeah, and that's the reality. I mean, some of the names, and obviously you've gone through it, whether it be lawyers, journalists, business people, the names that could be contained there could be exceptionally explosive. But again, we're assuming. However, if it is not the case, and those names perhaps are not there, I mean, isn't this fight almost an admission of guilt? Why does the president just not come forward and give us those documents and close this case and move on? It must mean there is something there.
Well, I mean, we know that prior to this record being sealed, I'm sure you remember that there were publications that did access some information and emails with regard to the funding. Some names did come out in the media, of donors and funders. Yeah. And I think that the factional politics with the ANC, within the ANC, is so toxic that the president is going to get pushback, and there's going to be incredible scrutiny over the individuals on those lists. And unfortunately, because of the kind of language that the EFF has employed, and specifically, it's very problematic and unsubstantiated attacks on the judiciary. There's a real culture, I think, of fear around this whole thing. So you may well find, the donors, and we don't know, we are speculating, the donors are really, really deeply fearful about their information being disclosed because of the kind of consequences that they may experience as a result of that. Yeah. And so the entire space is toxic. But sunlight is the best disinfectant, to quote my mother. And I think that if we have a look at this and we say, well, what will transparency bring to that? I think that one would probably argue that it would potentially be better for there to be a disclosure that this matter can be settled once and for all.
Indeed. Karyn, always a pleasure speaking to you. Thanks so much for your analysis. The story continues. The North Gauteng High Court, of course, is continuing. Karyn Maughan is giving us that analysis on those court documents. The North Gauteng High Court's virtual proceedings into the application of the EFF and amaBhungane Centre for Investigative Journalism to unseal Ramaphosa CR17 campaign records. Quick break. News after this.